We just need a moment to get set up. We'll be starting shortly. And just a note, the live stream has already started. Good morning. Welcome to the Office of Tax Appeals. We are ready to begin with the appeal of Safady. OTA case number is 220-610532. This hearing is being recorded and live streamed. Additionally, with us today, we have a hearing reporter, Ms. Alonzo, who will be transcribing this hearing verbatim. Ms. Alonzo or I may stop the proceedings to clarify or request that anyone slow down at any time to make sure our record is accurate. As a reminder, the Office of Tax Appeals is an independent and neutral tax agency. It is not a tax court, and all three judges are co-equal decision makers. We can ask questions at any time. Are there any questions before we go on the record? Okay. We're opening the record in the appeal of Safady, OTA case number 220-610-532. This matter is being held before the Office of Tax Appeals. Today's date is April 21, 2026, and the time is approximately 9 a.m. This hearing is being convened in Sacramento, California. Today's hearing is being heard by a three-member panel. My name is Keith Long, and I will be the lead administrative law judge. Judge Josh Lambert and Judge John Johnson are the other members of this tax appeal panel. All three panel members will meet after the hearing and produce a written decision as equal participants. Although the lead judge conducts the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. The Office of Tax Appeals is not a tax court. It is an independent appeals body. The panel does not engage in ex parte communications with either party. OTA will issue an opinion based on the party's arguments, the admitted evidence, and the relevant law. For the record, will the parties please state their names and who they represent, starting with the representatives for FTB.
My name is Desiree Macedo, representing Franchise Tax Board.
Could you be a little closer to the microphone when you talk?
My name is Desiree Macedo, representing Franchise Tax Board.
Thank you.
And my name is Ron Hofstall. I also
Thank you. And for appellant?
I'm Frank Mohan, representing Gary Safady.
We'll need you a little closer as well.
I'm Frank Mohan, representing Gary Safady.
Thank you.
And I'm Gary Safady.
Microphone's got to go on. There's a button to push to turn your microphone on.
I'm Gary Safady.
A little harder. You'll see a green light. There you go.
Hi, Gary Safady.
No, good. And good distance, too, on that one. All right. Well, the issues to be heard today are whether appellant was a resident of California during the period January 1, 2012 through May 18, 2012. At the pre-hearing conference, appellant indicated that he would like to give testimony. As a reminder, witness testimony is not required. However, testimony given under oath may be considered as evidence, whereas any other presentation is considered only as argument. Additionally, witnesses are subject to cross-examination. Mr. Safady, can you please confirm whether you'll be testifying today?
Yes, I'm testifying.
Thank you. And if you could just raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Moving forward with exhibits, appellant previously submitted exhibits 1 through 7, which were discussed at the pre-hearing conference. Thereafter, appellant submitted an updated exhibit list identifying exhibits 1 through 17. They include 1, FTB notice of action, 2, affidavit of Jeffrey D. Cabot, 3, affidavit of Selwyn Gerber, 4, statement of Scott Burdett, 5, affidavit of Salvatore Solano, 6, affidavit of Eleanor Safady, 7, statement of Jose Carlos Mata, 8, schedule of credit card charges in Las Vegas, 9, list of companies owned 2012, 10, list of non-California professionals used 2012, 11, response by Jeffrey Cabot to request for information, 12, reorganization agreement dated August 30th, 2012, 13, Veer Tower lease dated 12/2/2011 with layout, 14, State Farm Home Insurance, Veer Towers, dated 12/7/2011. 15, non-binding letter of intent dated 6/14/2011. 16, interim agreement dated February 13, 2012, MESCAP, and then 17, MESCAP and Venable billings with graph. Does FTB have any objections to these exhibits?
No objections.
Thank you. And then before the pre-hearing conference, FTB provided an exhibit index identifying exhibits A through K. There were no objections to these exhibits at the pre-hearing conference, and so they are admitted. Thereafter, FTB provided exhibits L through P. They are Exhibit L, respondent's request for information to Mr. Mata. M, Mr. Mata's response to respondent's request for information. N, respondent's request for information to Mr. Solano. O, Mr. Solano's response to respondent's request for information. And P, respondent's request for information to Mrs. Safady. Does appellant have any objections to Exhibit L through P?
I do not.
Thank you. All right, we are ready to begin with the presentations. Appellant requested 90 minutes for the presentation and testimony, and you may begin when ready.
Thank you. Maybe that's better. As you're all aware, this matter is in regards to a determination of whether my client Gary Safady was a resident of California for the calendar year 2012. It's been our position from the get-go that Mr. Safady moved from California, which he has been a long-time resident and had done a significant amount of development into the Las Vegas area, and particularly Veer Towers, in December of 2011. The only reason, or one of the only reasons he came back, was because he was involved in significant litigation with his long-term partner and cousin, Mr. Paul Filio. When you're trying to analyze a residency case, there are a ton of different rulings getting to each specific point. The particular problem in this case is Mr. Safady's life is not ordinary. It's not average. His particular situation wasn't an easy show to the Franchise Tax Board, in that it wasn't a husband and wife, 2 kids and the dog packing up the U-Haul van and moving to a different city. At that point in time in his life, he was recently divorced, had a significant litigation matter going on in California, and then recently broke up with his girlfriend, which at that point in time, he wanted to leave the state, and he in fact did leave the state. when you look at Revenue and Taxation Code 17014, in regards to residency, it's if you're in California for other than a temporary or transitory period. And in this case, the transitory period was probably from the last week of January all the way through maybe the third week of August. At that time and during that period, he didn't maintain a residence in California. The Franchise Tax Board points out in their briefs that he owned a property through one of his companies, and he owned another property through one of his companies, and he could stay at his parents' house, and he could stay at his brother's house, and we could stay all over the place. He could have done a Holiday Inn for all I care. The fact of the matter was, it wasn't his home. They were properties. And we'll go through each one of the properties to explain why they weren't his residence. Going on to the regulations, under Code of Regulations 17014B, whether or not the purpose which an individual is in this state will be considered temporary or transitory in character will depend to a large extent about the facts and circumstances of each particular case. It can be stated generally, however, that if an individual simply passes through the state on his way to another state, or is here for a brief rest or vacation, or to complete a particular transaction, or perform a particular contract, or fulfill a particular engagement, which will require his presence in the state but for a short period of time, he is in the state for temporary or transitory purposes. And as you probably all know, one of the leading cases is the Bragg factors, which talk about different factors to consider in trying to determine who is a resident, who is not. The difficulty with the Bragg factors is they don't really fit his life perfectly. For instance, the first one, in regards to whether or where the location of his residential real property is. The ironic part of this particular case is the only single-family residence that he actually owned was in Huntsville, Alabama. He didn't own one in California. He didn't own one in Las Vegas. He owned a single-family residence in Alabama, and no one alleges that was his real home. That was there when he ended up going to Huntsville. He did have some other properties, 2703 Nicholas Canyon. That was a very large single-family residence, 8,200 square feet. But by the time we got to 2011, that was no longer around. It did serve as his residence at one time, but not during the period at issue. 9800 Wanda Park was also another smaller house. I think it was actually smaller than alleged in the petitions. But that was remodeled to an office complex. They had put in a whole set of cubicles, 20 if I recall. Mr. Safady can clarify that when he speaks. And they brought in 2 T1 lines to house the office staff that was still around at that period of time. Wasn't quite a place to have a residence, especially when you had people going in and out of there for business purposes, that being his employees. He did have his parents' house to stay at when he wanted to, but a 50-year-old laying on the couch at your parents' house really wasn't what I would consider a residence. It's a place to stay while he's there. It's not a place he returned to. So really, he didn't have any real residential ties to California at all, and clearly didn't have a home, a place that he intended to go back to. The other issue with the property on Wanda Park is that was, at the time, it was being leased by O&S Holdings, was a company that he owned half of. The litigation dispute I referenced earlier with his cousin, who was also a half owner of O&S Holdings, he refused to allow him to even be there for personal purposes. He didn't want to spend one dime or have Gary benefit 1 ounce from staying in that property. The other factors, for instance, where your spouse and kids are. Well, in this situation, he's divorced. And throughout this whole period of time up until today, Mr. Safady's ex-wife and kids still remain in California, even though he hasn't. It's a little unclear in regards to what the time period is, because throughout all of the audit, we've been talking about the government, or the Franchise Tax Board, conceding the fact that when he bought a place in Florida, he was no longer a California resident, which really kind of isn't true, because even though he bought it, his original purchase of that property was for investment purposes. He thought he was getting a very good deal. And in fact, he probably didn't move out to California or move his stuff from Vegas until October of that year. So when you look at the factor of wife and kids and where the kids go to school, nothing's really changed. January of 2010, they were still in California. December of 2011, they are still in California. March of 2012, they're still in California. May 19th, August 21st, December 31st, they're still in California. Nothing has changed. So it's very difficult to use that argument that you have to be here because of your kids. There is an allegation in the pleading someplace that talks about the fact that he was under a court order to have his kids every other week. Well, that's all well and good, but that's not what he and the ex-wife had agreed to. She understood he was going through difficult times with this litigation, and therefore they had other arrangements. He could see him when they could. He talked to him on the phone. They did travel to Vegas a couple times to meet with him, to have a fun time. But that wasn't a fun time of his life that he wanted to share with his kids. And they had also agreed as a couple to leave the kids in California to maintain their current school situation, to maintain their social life, their friends, and not disrupt them, which they absolutely had the right to do. Back in 2011 and 2012, phone records. Mr. Safady basically operated off a cell phone, so tracking where he was, it wasn't a landline where you could see where his long-distance phone calls were. It was on his person wherever he happened to be. Since he didn't have a primary residence in California, he never claimed a homeowner's exemption. There's nothing to claim. He doesn't own one to claim one on. With respect to the numbers and days of California, I guess to give you a little background, when this audit took place originally, the auditor tried to put together a calendar based on his credit card. On the first probably 2 runs of that analysis, the auditor had done a very good job trying to figure out what a housing expense was and what a meal expense was and what an entertainment expense was, and kind of categorize them in an effort to determine where he was during that year. The problem with that is the actual credit card had not only Mr. Safady's name on it, it also had his assistant Carlos, it had his assistant Shannon, it had his kids on there, and I believe there was one in there that his parents had used. So when they did the original analysis, which has since been overcome, they marked all these different restaurants or places of business and came up with 240 days in California. Once it was narrowed down, I think currently it's probably 120 days, but I don't even know if that's correct, and Mr. Safady will tell you that. The hard part in doing that is 15 years later, we're sitting here trying to analyze where he was during the year. So in hindsight, it would have been nice that Mr. Safady had, 8 o'clock to 10 o'clock, I was in Santa Monica. From 10 to noon, I was in Century City. And then I went home, I had dinner. No one does that. I doubt you guys do that. You'll have appointments on your calendar. You'll have hearings on your calendar. There's probably not an entry in your calendar going home to the wife and kids to have dinner. So it's difficult to ascertain. The other problem with the calendar is that it had appointments where we know he was in California, but we also know when he was in Nevada. Nevada was a little different because a lot of the, particularly that time in Las Vegas, after the downturn, Las Vegas was hit hard, so they were hard up for bodies to be in Las Vegas. He got a good deal on the Veer Tower, Most of the stuff in Vegas, you can go to a buffet for $4. You know, they were trying to get people back to Las Vegas. They had a very difficult time doing that. So when you analyze where he's at, we have credit charges that we know are in Las Vegas, and we know he is the only one that would have incurred those. The costs in California, we don't know that he was the only one that incurred them. For instance, Carlos may have, his assistant, may have taken the kids out to dinner. We know there's a charge in California. We don't know if it's Carlos. We don't know if it's Mr. Safady. We don't know if it's his parents. We just know there was a charge in California. So it's very unclear from his calendar, although I think the most recent revision is probably as close as we'll get using a calendar, using the credit cards to determine where he's at. The other issue is the fact that if he's there during the day, there were many times that he drove home, you know, whether he went for a day trip or if he went for 3 days and drove home. I'm not sure really how you count that, because he would have gone back to his place in Las Vegas, you know, what he believed to be his home, to rest and get away from the Los Angeles hustle he's had for the last 30 years. So do you count that as a California day, or is that a Nevada day? I think it'd be a Nevada day in that he is returning to his abode, you know, the place he wants to return to, his home, the place where his stuff is. There are other indications that were brought up in regards to where he was at. For instance, a statement information file with the Secretary of State, a ministerial act that's probably done by somebody else. And back in those days, when they started the online process, you would pull up a California company, and most people would just check the same as last year box, which says Mr. Safady resides in Los Angeles. Probably the same thing happened in Texas, in Louisiana, and in Florida, where all of his other projects were. The other issue in regards to these factors is where most of his real estate investments are.
I'm sorry, can you repeat that contention with respect to the same as last year box for me?
The statement of information that's filed every year or every other year with the Secretary of State for California LLCs, corporations, and such, when the filing is due, when their original online version came on, you would click on your company, and then if you wanted to, you could change the manager of a company, or you can change the agent for service of process. Most people, Mr. Safady included, or his firm, or companies, I should say, would normally just check the same as last year box.
Okay, I understand. Thank you.
So it's a ministerial act, but it's been brought to support the fact that he intends to stay in California. But I think the same thing would have happened for the Huntsville properties, because that's where the office was. Doesn't mean he was in Alabama, doesn't mean he's living in Alabama. That's just where he'd be served as an agent for service of process. And along those same lines, one of the factors discusses the fact that where most of his investments are. And yes, he had California investments, he had California projects, but most of his net worth and projects were out of the state, that being in Texas, Louisiana, Huntsville, Alabama. So if you compare them, he has more things, way more things, out of the state based on value and numbers than he did in California. There's other minuscule ones, like where did he register to vote, where did he have his driver's license, and he got a new driver's license in Nevada, and he registered to vote in Nevada. There's also a list in, I believe it's Exhibit 10, Appellant's Exhibit 10, that talks about his professionals and where they're from. You know, he had litigation going on all over the place, and that was a common occurrence in his industry. You have landlord-tenant disputes, you have construction disputes, you have lending disputes. There was all kinds of other litigation going on at this time, but he didn't need to be in New York, he didn't need to be in Texas, he didn't need to be in Alabama. This one was specifically something that he had to do because he was the only one that had the knowledge and the ability to put together where things were. You know, if you're talking about a 30-year partnership of 50 entities, and he wanted to see mall's permit for concrete or construction bill for concrete. There was nobody there back in those days to even understand where the project was, whether it was still retained by the two partners or if it was disposed of or dissolved. There was nobody there for that. He was the only one that could do it. It would have been great if they could have taken this, you know, I don't know how many boxes, a 10 by 20 storage unit, 8 feet high, if they could have taken all those boxes and shipped them to Las Vegas. But all the attorneys and all the subpoenas and summonses for all these records and inquiries were all in Los Angeles, so it was much more cost effective to have Mr. Safady come into Los Angeles to try to figure these out and find them for all these different professionals, whether it's the accountants, the consultants, the attorneys. No one even knew where to start. And that's both from the allegations that were made against him for mismanagement and misappropriation, as well as trying to work out the final settlement details of this massive conglomeration. And at one point in time, it was just, I would assume, just south of $1 billion in value of assets. When 2008 hit and the economy tanked, that was a big hit to this industry. It was a big hit to him financially and personally. And then to come around 2 years later and be attacked for doing something wrong made it personal. And Mr. Safady will testify that when he moved, he moved. He rented a 3-bedroom place. He didn't rent a studio. He rented a 3-bedroom place, though he'd have a place for his kids. He bought furniture. He had nothing to move other than stuff in his car, you know, clothes and close personal belongings. But he had it all set up for them, and they, in fact, did visit. It was fairly easy on the bank or on the credit card statements that I mentioned earlier to figure out when he's flying back and forth to Las Vegas. But you know, if it's a 3.5 hour drive from where Mr. Safady was in Los Angeles, by the time he drives to the airport, gets there an hour early for TSA, checks in, hops on a plane for 45 minutes, gets out of the airport, finds a cab, it's just as easy to drive sometimes. And he can do it at his convenience, not based on the airline schedule. He doesn't need to make a 7:05 flight to get there at 8:10. He just hops in a car and leaves. And many times his assistant drove him after a long day. He didn't trust himself driving, you know, 3.5 hours after working 12 hours looking at boxes, which was good. So considering, you know, the Bragg test and the actual law and regulations, to me, the query here is, where did he go back to? You know, we've acknowledged that he had stayed at his parents' house during that period of time. He crashed at Wanda Park. He stayed with his brother. If he had that many places to stay, he's not going back to one place that is his home. He's just getting his job done and going home. For those reasons, I believe Mr. Safady was a non-resident for all of 2012.
Thank you. And you can just go straight into your witness testimony.
Okay. Can both stay on?
Both can stay on, right?
Would it be possible I use the bathroom really quick?
Sure. Let's take
I
10
need a
minutes
minute,
to
couple minutes, yeah. I
Yeah.
should use the restroom.
we'll take a 10-minute break. Everyone, please come back at 9:45. Thanks.
Thank you.
And we're going off the record now. But I If we're ready, I think we can go back on the record. As a reminder, because this sometimes happens with witness testimony, please be sure not to talk over each other so we can create a clear transcript for the record. All right, we're reopening the record in the appeal of Safady. We are going to begin with witness testimony from Mr. Safady, and you may begin when ready. Thank you.
Thank you. Mr. Safady, if you could you explain what you do for a living and particularly up and through 2012?
Yeah, sure. I was the managing partner and founder of ONS Holdings, which was a development company and management company of assets throughout the United States.
What type of projects would you have, and kind of maybe start with how you started and where you ended up?
Sure. Yeah. So I had just gotten married in 1993, and I didn't have any money. I probably had $5,000 in my name, and I lived with my grandmother the first 3 years of our marriage. And I started off as a real estate broker, and I was starting to make some money. And then our third year, we were having a baby. Instead of buying a house, I bought a small piece of land, and with my cousin, and we built a 5,000 square foot commercial retail building. And then we did another building. So 5 went to 10, 10 went to 20, to 30,000 square feet. And then over a series of, through 2008, we built 4 to 5 million square feet throughout the United States. And so I was just always super entrepreneurial. I pretty much, my cousin was a silent partner, and I pretty much built it up from 0 to almost 600 to 800 employees throughout the United States.
Was your cousin also a partner from day one, or did he come on after your first or second brother?
No, from day one, we were very close.
Were you very close before this business relationship started?
Pardon me?
Were you very close before the business relationship started?
Yeah, we had a good personal relationship. He was my dad's first cousin.
And then let's kind of move forward. You had, significant properties all the way up through 2008. You were married in 93?
1993, correct.
And any kids?
3 children.
At some point in time, your marriage started to become on a rocky path?
Yes, around 2006 or so, 2007.
Were things still good in the business?
Pardon me?
In 2006 and 7, when you were having marital difficulties, was the business still going well?
Yes, we were still doing well in business.
When did the business start to fall apart?
Well, I think there's 2 key dates. In 2000, at the end of 07, the mother of my children and I went through a mediation to separate and to get a divorce. And in March, I think it was of 2008, I signed the divorce basically with little resistance. We just, we had, for the sake of our children, I pretty much gave her everything she wanted, and I just wanted to move forward. And 3 months thereafter, I was blindsided when the entire economy, the global crash of 2008, and it was like being hit by a brick wall. Everything changed in my life.
The problems with respect to the economy hitting you, was that tenant problems, bank problem? What kind of problems did it force you to take charge of?
I mean, it was a big challenge. I got a divorce. I bought her out of all that properties. I didn't have the cash to do it, so I took back notes from her. We had tenants over this series of the middle of 08 through 2010. We had loans coming due, tenants renegotiating, tenants going to bankruptcy. We had a particular loan in Huntsville, which was say a $200 million construction loan led by Wells Fargo and 8 banks. 6 of the 8 went into receivership. So it was a very, very challenging time. And then my partner started to turn on me, and basically in 2010 filed a lawsuit against me, and it was basically trying to take over my interest.
What part of 2010?
I would say sometime, it was so long ago, but mid-2010, I guess, early 2010.
And he was trying to take over your interest. Did that something that you were discussed, or was just litigation, or how did it start?
It started with obviously conversations, and I just remember one day he said, he phoned me up, said, "I'm going to humble you," and he was, I knew his style from years of watching him grow his business, and he kind of managed by intimidation, and he was coming after me, and he had the liquidity. He knew I owed my ex-wife money, a significant amount of money. He called her and tried to get her to go after me legally as well. He threatened also, when she didn't, say he's going to take her house. Called my dad, his first cousin, who was getting older in years, and would harass him. It was just, I knew he was coming after me, and I knew this is all I had left. So I had to, I had no other choice but to fight and figure out how to fight.
In 2010, you signed an interim agreement, I think it was called.
No, we went through a mediation. That was in June of 2011.
So was there any agreements reached in 2010?
I don't believe so. I know we went through some hearings, and he tried to get me removed as manager of the company, and I prevailed in both cases. Then he fired his law firm and hired a really big, I think it was Munger Tolles, to go after me. And at that point, when he brought the new lawyers on who took a bird's eye view at the case, they said to him, "You better settle with Gary." And that's when we went through mediation. I'm not big with conflict, and I was always willing to talk to him and work out a settlement. And in hindsight, where we ended up on the matter is exactly where we should have, and we didn't have to go through this. But for him, it was very personal, and it was an opportunity for him to, I would say, put his thumb on me. So it was a very difficult period.
So the interim agreement that was reached in June of 2011, was that fairly detailed, or a final agreement, or what was the purpose of that agreement?
I mean, it was really the first step, a very, very high level of moving forward with a proposed path for settlement. I didn't think we'd be done because there's a lot of multitude of issues, and I know how he was. And then we had a subsequent mediation in December of 2011, and from that June through December, the attorneys were going back and forth, and I feel like we were about 95% with what I thought were all the issues being completed leading into that December mediation. In fact, I even said, "Why are we even having this?" Because it was up in the Bay Area, and they're like, "No, we need to go." I guess they also want to try to, have a lunch together and all that. So we had that mediation.
And the mediation was successful? There was an agreement at that date in regards to however you're going to reorganize or split up?
Yes. So it was obviously not the totality of it, but it was substantially there, where I felt good enough about it. I actually felt good about it really in November, because most of like these big issues I thought were resolved then.
Okay, let me take you back, in 2010, and I guess through most of 11. Were you primarily living in Los Angeles? That would have been after your divorce, but before most of this litigation?
Yes.
In 2011, where were you living?
Pardon me?
In 2011?
2011, I was, well, I had a bed there at Wanda, but mostly I was staying at that point with my, my girlfriend at her house because I was trying to raise capital any way I could, and our O&S Holdings office, we were buying a building in Beverly Hills that we fell out of, we did not close on the property and foregoed. We had $1 million deposit that we lost. And at that point in 2010, we had all these people in the office and still like quite a few people from in the LA office, like 20, 25 people. And so I said, just take over Wanda and I'll charge you $10,000 a month rent. So we ended up gutting. We had about 25 workstations. We brought in 2 T1 lines, which was significant back then because AT&T was like, why do you need 2, T1 lines? But it was to communicate with the other out-of-state properties, et cetera. And it ran all of our network servers and stuff. So we went ahead and did that. Then for me, it got really overburdensome having all those people there. And then when Paul found out that he was paying rent there, he knew about that, but he didn't know that I was staying there. He just blew a lid and said, I'm not, paying for your fucking residential property, for you to stay. And so I basically left. I converted the, it was a small place, like 2,000 square feet. And so I took the upstairs. I just made a conference room out of it. So it was where we always had people there in and out. So it was a place. I saw that as a place for me to make money, and I ended up leasing it because I was just trying to make rent out whatever I could.
The Nicholas Canyon property, in 2011, did you stay there?
No, never.
The income from the rents, that income would have gone to O&S?
No, that was directly to my entities that owned the property, 9712, that entity, and then whenever I leased Nichols Canyon, it would go into the Nichols Canyon bank. They were separate bank accounts.
Okay. Continuing on after the June interim agreement, did your relationship with your girlfriend continue on through 2011?
No, it ended around, I would say, right around October 2011.
At what point, you have your divorce, you have the beef with your cousin, your partner, you have your girlfriend leaving. At what point did you decide that you wanted out of LA?
I mean, I was always contemplating it, and I would say right around, I really started thinking seriously about it when we signed the June 2011, and then around October 2011, I wanted to leave. It was a bad ending with my personal relationship, and I wanted to move on with life. And just like the straw that broke the camel's back, I wanted to leave. And I want everything that was happening to me my whole life, it just felt like the walls were closing in on me, and I just needed to go hang my hat somewhere else.
When did you start to consider Las Vegas as a potential place?
I started to search around October, November, And then in December, I signed a lease in Las Vegas Veer Towers.
What was your thought process in regards to why you picked Las Vegas and not some other place?
I had history there. I built a center there. I had a very good personal friend of mine that we shared the same interests, and he had children like me, and he was doing infrastructure projects in Africa, and I've always been fascinated about that and wanted to do that. And plus, the gentleman that owned, I knew the owner of the MGM, and I know they were in serious trouble with their project that I subsequently was living in. So I thought there were some real opportunities there for me to move there, and also I could be even close to my kids when I need to see them, to go back. But that was really a place that I moved to start a new life and to really have some peace and quiet in my life.
Did that provide you peace and quiet?
Well, to be honest, my first few nights there at my apartment, my blinds weren't on, and I was living on the Strip. It felt like I was having an epileptic seizure with all the lights of the Strip. So it was pretty. That was not too peaceful until they put those blinds in. But I enjoyed it. It was just like self-contained. I didn't have to go anywhere. I had the gym. I had the food downstairs. It was familiar to me, and I had some friends there too. So it was nice. What I didn't have was the pressures of, I hate to say this, but my family and the children, the work. I didn't have that there.
So you signed a lease. Did you have a bunch of furniture to move from Los Angeles?
Excuse me?
Did you have a bunch of furniture to move from Los Angeles once you leased the apartment?
Yeah, I had several friends. From all around the world, actually. My friend Brent would come. My friend Steve Kritikos, who's my former tenant in Vegas, who lived in New Hampshire. My friend Daniela from Europe came. My friend Natalia from Europe came to visit me. My friend Jonathan Keys from Israel came to visit me. So I had several friends throughout the period of time there that would come. My buddy Judd from New York came. So I always had, being in Las Vegas, there's always somebody coming in for a convention or to have fun, etc. So I always had people in and out.
I mentioned earlier about your calendar. Would that be things that you would put on your calendar?
No, I didn't. By that time, I never really used that calendar so much, and I'll tell you why, because it was on the network of my system. And at that point, I was, my cousin and all of his lawyers had access to everything in our server. So everything that I put in there, they would have access to. So it was a fully network, and I didn't want, people know what I'm doing.
If you didn't have that possibility of everybody seeing it, would it have been likely that you would have kept a better calendar?
No, probably not.
So you're in the Veer Tower in Las Vegas, and your lease is from December 2nd, 4th, something like that, and you had a full year lease. Did you have to move any household furnishings, couches, TVs?
I bought all brand new furniture. When I got divorced, I literally just left with my clothes. She got everything.
And did you have things? I assume you had something to move from Los Angeles to the Veer Tower, even if it wasn't furniture or a TV. You had personal effects. Would you have moved those, or is that just something you threw in a car and took off with?
It was just stuff in the car and took off with. There was really, Nichols Canyon, all that home was staged. I was trying to sell it or I was leasing it, and I was just trying to rent that. And Wanda, by that point, it was basically all office space.
Do you remember, again, this is 15 years ago, but do you remember how long after signing the lease you physically moved to Nevada?
A few days, couple days.
And was the furniture already there when you got there, or did you have to get there and figure out what goes in there? Or?
I would say maybe probably 90%, you know, quite a bit was there.
And so you were in Nevada, and again, I'm referring to calendar, which I acknowledge is not perfect, but you were in Nevada from most of December,
I believe so.
and then January. When you had the mediation, that you said it was in Oakland in
Yes,
December, and everybody was happy, shaking hands and agreeable.
yes. And we had a lunch. They brought in food and they sat next to us. Like, he and I were very close. I mean, we used to travel with our kids together every summer, you know, and take trips together. So it was pretty heavy to have, you know, the way he turned on me and, you know, what happened. It was just completely unfortunate.
So as time goes on, does he cease in trying to make this split harder on you, or not?
No. After we signed it, we had our first board meeting, and they brought in, I want to say it was FTB. I know it's the same acronym as you guys, but it was a third party that had the tie-break vote, and they were like the administrator and ran everything. And our very first call, it was, you know, typical fashion. He had to rip someone apart, and I was the guinea pig, and he was trying to get me to be thrown out of the company, replaced as manager. And mind you, there's nobody else that immediate around there that could have taken over and dealt with the multitude of issues that I was dealing with, or we were dealing with as a company. And fortunately, when my lawyers said, well, you're going to have to pay him as part of the agreement, $5 million to remove him as manager, and I maintained my equity. And I said, sure, you want to? Let's do it. And then he didn't want to pay it. Instead, immediately following that, their lawyers wrote an allegation because I was owed development fees close to $50 million that I never took. I helped the business grow, and I deferred my development fees. I never took a salary. I only got development fees. And so he filed to our attorneys. They wanted a complete audit. They said I was embezzling money and I was overstating all my development fees. Well, now and then they said if we find out for cause, then they have a right to terminate me, and they have the right to, I think there's a penalty against my equity and stuff like that. So he basically dragged me back down that path, and then the attorneys, it wasn't just 35 entities. I know we see all these agreements. There's 35 entities, and it says there's only $2.5 million in legal fees. That was my half. The total legal fees on this was over $5 million over this period of time of, I would say, 8 to 12 months. Majority of it, I believe, was between January through August, because the issue is this: the December, you think it's okay, you're done, you're going to move forward. What happened was when they peeled back and realized there's over 35 entities that we own, all separate LLCs, all separate books, that he and I are owning. He's now going through a divorce at this time, and his wife's attorneys. Now we have my attorneys, his attorneys, their attorneys. Now we're going through the long form agreement, and I got to tell you, it was probably 8 to 12 inches high of paper, and they were going to do with all the tax lawyers and tax accountants. And in October of 2011, the accountant that he and I both used, and also were the company accountants, resigned from me and sided with my partner, because I had a waiver when I brought them on, and they both went up against me. And my account, I had to hire a new accountant, and my lawyers recommended an attorney that's in the office building next to his, And that's when I brought on Gerber Associates. So when we were doing the long-form agreement, it was extremely onerous and extremely complicated. And just like looking at this case on paper, this is not a black and white case because there was just a multitude of issues. There were intercompany agreements, personal loans that he would sign for because he had more money. I would hold back to them. And his interest, in my belief, was to drain me all my cash and all my equity. And at that point, we had to get, there was about 35 entities and boxes in the LA office of my attorneys in the conference room. And then there was another 15 entities that were, I'm going to say like old entities or properties that we developed and sold off in the Santa Monica storage. So I had to bring all that back. I put it at the office in LA, and the rest of the stuff was in Century City. And then they would ask me questions literally, oh, in 1993, you know, you paid this contractor this, show me where that invoice is, show me the canceled check against it to make sure it all lined up. And that went on for 60 to 90 days. Meanwhile, they were still moving forward with the agreement. And it was, I mean, it was, you know, what can I say? It was a tough time of my life that I had no choice but to fight. And because the last thing that I had to give, you know, really for my children and to pay off my ex-wife.
During this same period of time, I think we've discussed, you had other litigation going, whether it's landlord-tenant, banking, foreclosure.
No, I had probably 8 law firms in 5 states, and we had a major case with AIG happening in New York, happening in Alabama, and in California on a construction defect claim. I had litigation in McKinney, Texas, I had a law firm there. We were doing a workout with the city and contractors. Louisiana had issues. Louisiana was I think at that time as well. But I just had multitude of issues. We had, you know, slip and fall claims. We had a lot of issues.
Did any of the other litigations require your presence, or is that something you would handle by phone, or the attorneys just handle it and tell you how it's come out? What was the need for you to be involved in all these other, besides your cousin's litigation?
No, that was more like a construction defect litigation. It was pretty cut and clear. It was experts and all that they needed on that. I would be involved, but they didn't need me that much. They would call me if they really need me or need something like that. This one was much different because they couldn't figure out in tying all these entities together and how they relate to one another. And in fact, I noticed in the briefs they said, oh, then you formed in 2012, I think it was on the state side, all these entities in Alabama. Well, those have been formed since 2004. But then they were got to figure out, well, why do you have 8 entities? And well, one of them was an HOA that we did to own the lakes that I built. And each component of the project had its own LLC, and it was almost a 2 million square foot mixed-use town center. So, you know, and then we had development agreements with cities, and we had in Joliet, Illinois, we had a major issue there, and that was going to be a 3 million square foot mixed-use town center that we had a huge development agreement that I negotiated with the city, and that was going to be my best project. And, you know, the sailing, all ship sails and high tides, that thing was been by far, we were 75% pre-leased, we haven't broke ground, it was done. And then you just don't know in life what happens, and we just got blindsided. And, you know, we bought that land for 40, and we ended up selling it, you know, in 2013 or 14 for like $8 million. So we just had, you know, and I didn't have the power because the 2 overruled me because it was worth a lot more, but he didn't care. It wasn't so much how much they got, it was how little I got. throughout that whole process. And so, you know, it was, it's life, you know, and I'm still standing today, so I'm pleased with it, but, you know, it wasn't clearly the happy ending that, that you'd brag about or write home about, you know, and so it was tough times.
When exactly was the board meeting where Paul came back at you with all these allegations of mismanagement and fraud? And
I think that was immediately following in January, after January's. So, middle of January, I guess. So
all the other litigations really, they needed your input, but they didn't need your presence. So in mid-January or whenever it was in January, these allegations of fraud or mismanagement or misappropriation, those were personal to you.
absolutely.
And there was no one else there that could have figured out
Look.
where receipt number 552A is. And
I wish none of that happened. I wish I could just gone on in peace and live my life in Nevada and at my home and be quiet. A part of myself died during 2008 to 2012. Even my connection with my kids, everybody. It was a tough time of my life.
when it was first brought up and these allegations were made against you, in addition to being available, which I assume that a lot of the workout or the roll-up or whatever they did to get you guys to separate, I would assume a lot of that would have been something that you could have handled by phone?
I'm sorry, could you repeat that question?
In regards to to me, from what you've said, is two different tasks. You have the defensive responsibility to justify what you did as the manager, over this 30-year period on the 500 projects. But in addition to that, someone needed help in determining what these entities were for purposes of trying to roll them up and to sever the two of you. The stuff that was severing the two of you, could that stuff have been done not in LA, or was it just a convenience that you happened to be in LA for this accusations that you also helped with the other part?
I mean, it was almost imperative. I had to be there, and I had to go because I didn't have the files. They were at my attorney's office. I had some from the previous, but you're talking about unwinding 30 years, nearly anywhere from 600 to $1 billion, wherever you want to call the valuation. You're talking, I'm spending between $200,000 and $500,000 a month in taxes, legal, financial. I'm there for a reason, and I couldn't wait to leave and go back home.
So when you decided you had to come back, which again, correct me if I'm wrong, but I think we're leaning towards like the last week in January, maybe even February, from these allegations. At that point in time, how long did you anticipate how long you would be in California?
No, I didn't at all. I would go with the pretense I'm going to go there for a couple, 2-3 days and come back at the most. Based on the allegations made, were you realistic in thinking that you would just go and find these 20 receipts or 5 million receipts or whatever it was and be done? Yeah, in part, yes, but also in part, there'd always be questions, and there'd be like, what's this entity, what's that entity? And I had to go to the conference room at the lawyer's office where they had all their files, and that's where the other side had unfettered access to it as well. And then we brought the files from Santa Monica to the office, which I would do, which are the older files, which were not part of the roll-up because they were entities that had already been sold off.
Was there anybody on their side, so maybe the accountant that sided with Paul or went on Paul's side, was there anybody else that could figure this out on their side?
No, because like I said, Paul didn't step one time in our office, and we had offices in Santa Monica prior to all this up until 2008. I don't think he ever stepped in the office one day.
Was there anybody on their side that could call you on something you found?
Yeah, his wife's brother was extremely asking a lot of questions.
Was he just asking questions, or do you have knowledge that could back up?
He didn't have knowledge, and he had zero real estate experience other than a hired gun to ask questions and try to poke and just make things difficult.
So I'll say end of January, beginning of February, you thought you'd be there for a couple of days and handle this and then be back home in Las Vegas?
Correct.
And obviously that wasn't the case. And again, I don't even know if you really know how often you were in California or Vegas for that matter because of the calendar, but does 120 days seem reasonable?
I mean, it seems pretty reasonable, I guess. I mean, you're talking about nearly $1 billion settlement, and only being there it seems like I should have been there more regarding this matter. But I just wanted to leave. It's all due respect. I loved California, but coming back here, I haven't been back to California since probably almost a year now. This last, since the last time I was here, just almost like a PTSD. It was such a heaviness for me to come back to California. My amazing memories, I grew up in Stockton, California, and my parents never had a lot of money, but their wealth was in their family. And so I loved growing up. I tell my kids, I wish you had my childhood. You got a lot more things than I ever got. And I know what motivated me to go out and work as hard as I did was I wanted to give my children and those I love in my family everything that I never had. And so I just worked hard. But back then, from when after the divorce, when the 2008 collapse hit, it just felt like I'd wake up with a target, a red dot on my head every morning.
Let's talk about your move to Vegas. Okay, you have a 3-bedroom apartment. You're on the Strip. It's fully furnished. Your intention was to have kids there. What was your social life like in Las Vegas? Did you go out much? You just crawl on a ball? And
I mean, at that point, it was my mood was still, pretty somber, and I didn't have the liquidity that I once had. And I owed my ex-wife a bunch of money, but I mean, the casinos, I would have access to shows to go to, so I would see the shows at the casinos, and I would see my friends, but I kept to myself quite a bit. I go to the gym upstairs. It was a tough time for me, so I enjoyed just being alone and left alone and kind of out of sight, out of mind.
you had mentioned, I think, in the conversation you had, Mr. Hofstall, that you severed your ties with your church in Los Angeles?
That's correct.
And what was that? What's the name of that church?
I mean, there was really two. There was St. Nicholas and Our Lady of Lebanon, and I was on the board of finance for that one. And St. Nicholas was my grandfather was an Orthodox priest, and the baptism area there was dedicated after my grandfather, and so I was a member there for our whole family was for many life, and it was just leaving. It was just departure from everything and cutting everything off in my life. I mean, it wasn't easy. The hardest thing was saying goodbye to my kids, and seeing the tears in their eyes, But I was never abandoned. I was always a good dad. I was always there for them. I would call them and talk to them on FaceTime, and I'd be there as much as I could. But part of me was lost at that point. Part of me was just, I was tone deaf with respect to any kind of personal relationship in my life.
So you mentioned you told your kids. Did you tell the rest of your family? Did you tell your friends? At what point in time did that happen?
I would say right around November. I first told my kids, and then my parents, and of course my mom, got extremely worried, and, you know, my dad understood. He was, you know, more of a rock, and, but they knew, you know, everybody sees you up there. They don't see the struggle that you did to get there and then try to maintain it and then have everything just come crashing down. So it was an extremely humbling and kind of deafening experience.
When you got to Vegas, did you, let me back up. You said you resigned from the church. I assume that wasn't an issue with the church, it was just an issue with being the church in LA.
Yeah, exactly.
Did you rejoin a church in Las Vegas?
I joined whatever St. Paul the Apostle.
How involved were you with that church as compared to how you were involved in Los Angeles?
I wasn't that. I would just go there, you know, I would go there to do something unselfish, you know, where I could have been easier in bed or working out. I just went there just to pray and kind of do something unselfish.
And again, we've hit your calendar, and a lot of your personal stuff wouldn't have been on the calendar in the first place. But you mentioned you had friends come between December of 11 and I guess when you finally left in October or November of 12. How many visits do you get? Did you get a day visit? Did you get an overnight visit?
Well, if they can, they would come for overnight, multiple nights.
And how many visits do you have?
I mean,
Or how many different people?
from what I can remember at least 8 or 9 guests that came and stayed there and spent the night, etc.
All friends, business associates, who were they?
99.9% friends.
And your kids visited?
My kids visited, not as much as I like, but they came. And they always had, you know, that's why I had the full 3 bedrooms.
Do you remember how many times the kids came in that year period?
I don't. They came a couple, 2, 3 times probably, not that much because they had school. And their mother was super strict with school and studies.
And then your friends, were they Los Angeles friends? Were they from around the world? Were they?
All over, from Europe to U.S. to a few from L.A.
And would they stay for a couple days, a week, passing through?
No, they would stay for multiple nights.
We can't hold you to it, but if you had to guess how many days you had friends stay at your place, do you have a guess?
I mean, at least 30 nights because
About 30?
they're all, yeah, I mean, they don't travel, like my buddy Jonathan from Israel didn't come and for only 2 or 3 days, you know what I mean? So, anywhere from 2 to 5 nights.
Would you have any idea or recollection what time of year they would come, or?
No, just various times. It's too long ago.
Do you have memories of what you did with any of them that stand out?
Yeah, I mean, we would go out, we'd go downstairs, we would gamble, you know, I mean, nothing big. I didn't like, I realized in gambling I hated losing more than like winning. So I just tried to go down there and do things. We'd see shows. There would be, let's say, bars downstairs. We would just hang out. We'd walk the strip.
So you don't know what time of year, but you have a recollection that it was the Beer Tower because that's the only place you had in Vegas?
Yes, correct.
Okay. I think we've hit this before, but to reiterate, do you have any recollection of how many times you would have had to travel back to Los Angeles?
I don't. Anything I said would just be a wild guess. You know,
Would you normally fly? Would you normally drive?
I would do both.
And
I prefer driving because I don't know if they had TSA back then, but the lines in Vegas, you always do Southwest. I mean, they were a nightmare.
So it's probably quicker just to drive in the first place?
Yeah.
Would you always drive yourself, or did Carlos drive you back and forth at times?
Both. Carlos would do it too. You know, I would just, it was a good time to think when you're on the road.
Was it an opportunity to get work done, or was it just basically a good place to take a nap?
It's a good place just to see nothing.
Okay. When you came back to Los Angeles for these, to defend yourself on these accusations, what was your social life there?
Pretty non-existent. I mean, it was embarrassing to be sued by your own cousin and being accused of these things. So it was, and at that point, my father was in poor health. It just, there was, did I go out? I probably did. Do I recall how many times, or was I having a good time? Probably not.
If it wasn't for the litigation, I know your father took a fall in Nordstrom's, which is set forth in the petition, I think at the end of 2011. If it wasn't for the litigation, would you have spent as much time with your folks?
Probably not as much time.
So were you visited your folks because you were there for litigation as opposed to going there solely to reconnect or visit your folks?
Yeah, you know, there was key points during my dad at post-fall, and then they gave him a blood transfusion, and I remember him at the house, and they said he was a hypochondriac because he just got out of the hospital for 2 days, and I'm like, no, I had to call them. I'm like, no, he can't get up. He can't even physically keep his body up, and apparently they didn't tie something off, and he was draining blood inside of his body. It was a nightmare. So it was a hard time because I watched my dad go from 225 pounds down to about 145 pounds, and his heart was producing too much protein and was eating himself from the inside out. And by the time he passed away, like a year later, he was, you know, we were feeding him his medicine as a baby with aspirin, and he couldn't even barely swallow it. But you alluded to something earlier about this litigation, and I think everybody agrees on one thing. When this litigation was over, I never returned back to California. And had it not been for this litigation, we wouldn't be here today. And had it not been for a sale that took place in Alabama, we would not be here today.
And that sale was of one of your projects?
That's correct, Huntsville. That was only the retail portion only.
And that sold in May?
Yeah, May of 2012.
And was that under contract for a very long period of time?
Pardon me?
Was that under contract to be sold for a very long period of time?
No, I don't remember how long. It was probably a 90 or 120-day escrow. They were buying the retail portion of the Huntsville project.
So it wasn't under contract when you actually left California in December of 11?
Not that I recall. And we weren't actively, it wasn't actively listed or anything for sale. They approached us, the buyer. It was a REIT. And they had to, I think they had to close. They were in exchange or something. So we sold it.
So then going on in 2012, you're going back and forth to Vegas, always returning to Vegas. Did you have any stuff in, we talked about the potential of having Wanda Park or your parents' house or your brother's house. Did you keep stuff there, your stuff, or are you just walking around with a suitcase and some clothes?
I just had a little roller bag.
When this eventually came to resolve in August, how much earlier than the actual execution date did you think that things were going to be resolved?
I mean, can you repeat that?
So if you signed the agreement in August of 2012, the reorganization agreement, how much earlier than that did you think, at what point in time do you think prior to that, it would be a done deal or very, very close?
I would say almost a month before.
And the next 30 days was just attorneys typing pages up?
Yeah, the attorneys doing that and all that. I mean, it was, and even after we signed everything, when we would do our phone calls, my cousin would still act up, but it would just be yelling to be yelling, you know what I mean? So it was sad.
It wasn't done till it was done?
Yeah, but it was, at that point, everything was resolved.
And then once it was resolved, was there a big signing party?
No.
Everybody just signed their own copies and?
I think we all signed separately, and I signed my signature pages, I think in Santa Barbara, if I'm not mistaken. We all went up there, but there was no kumbaya moment at that point, like the December 2011 mediation.
And then shortly after that, you went back to Las Vegas?
Yeah, I returned home.
Do you remember if you ever came back to Los Angeles the rest of 2012?
I don't recall. I may have to come see my dad, but I just don't recall if I came back or not. It's too long ago.
And it wasn't on your calendar?
No.
Do you remember what you were driving in 2012?
I think I had a Range Rover.
And that was exclusively yours?
Yes.
Did you own other cars?
Huh?
Did you own other cars?
I don't think so. I think I sold them all by then.
Would Carlos have had a car?
Carlos had his own car, yeah.
Would that have been your name, or do you know if it's his name?
No, I mean, as I subsequently remembered from the documents, I signed the lease for him because he couldn't qualify.
And you never registered any cars in Nevada?
Pardon?
You never registered any cars in Nevada?
No.
That wasn't important to you?
It wasn't the top of my list, believe me.
Do you recall when, excuse me, did you recall when you eventually moved to Florida?
I mean, I think September or October, I think October 2012.
Did you buy the Florida property as your intention to move into it?
No, I mean, I knew the building very well. I'd stayed there before several times, and I bought it because I got a great deal on it. And quite frankly, I never saw the inside of it, only on the internet, you know, or from the broker. But I knew I was getting a good deal on it, and I bought it, and I ended up, I think, moving in around, like I said, September or October. And when I moved in, I was like, wait, I thought it was that unit across the way, because this one has blacked out windows. And but I knew I had a great deal on it. I was like, no, I want that one. So I ended up moving in there, and then I ended up going to sell it. And I think I did sell it like 6 months later, and I made almost an $800,000 profit on it. And I rolled it into the other unit that I bought across the way, which I really wanted.
For a similar price?
It was more money, but I used the profit to buy it.
Okay. It's my last question. In determining when and how long you returned to Los Angeles for this litigation, was there any fact, I mean, did somebody tell you to come? Did you get a complaint saying you did this wrong, and this wrong? What spurred both of your coming to Los Angeles to go through these boxes or to help the attorneys or accountants, and what triggered you to come back to Nevada?
What triggered me to what?
To return to Nevada?
I mean, I came there specifically from the attorney's request or the accountant's request or having Gerber understand. I was there for those reasons, and I went back to Nevada because that's my home, and I couldn't wait to get back and out of LA.
But did Gerber call and say, "Hey, I have no idea what the hell this thing is," or?
I mean,
What spurred it?
to be fair, none of these guys knew how complicated. Even if I try to get a bank loan, they don't understand. I have to sit down and literally go through my whole life. I'm not a 9-to-5 job. I was self-taught. During college, I worked for Tudor Sleeve. I was a laborer in the laborers union. I woke up at 4 a.m. I worked hard all my life. And I didn't have a normal job. I eat what I kill. That was it. And so I'm super entrepreneurial, and that was the genesis of my career. And a lot of people, it's hard for them to grasp it, they get their hands around it. But that's who I was as a human. Even like today, I'm unemployable. I have to still go out and hustle every day and figure out new businesses and go work wherever that may be. And that was no difference than during my career. In 2009, I had someone told me, and it wasn't about money, it was about passion, and I loved what I did. And in 2009, someone told me a story about the children, a true story about the children in Africa. It was a movie, and I was like, oh my God, we have to make this. And we made that movie in 2009, and it was a heartfelt movie, true story about the children in Uganda and Sudan called Machine Gun Preacher. And subsequently to that, I ended up in 2013, I was on a trip in 2012. I went to Africa, and I ended up opening an office in Liberia, Africa, and I ended up helping them under Obama administration get Power Africa to light up that city. And so it was like almost a calling, but I had passion to do that, and I was doing business there. And so I didn't have a set defined job where people can just look at it and say, oh yeah, I understand it. It was a pretty complicated, ONS was ran the same way. And even my cousin, he was a brilliant man and is a brilliant man, he's still alive, but he was super entrepreneurial. And we had a bowling alley in operations, and we redid it for Santa Barbara, and we remodeled the whole thing for the community. So, it was tasked on me to do that and figure out the operations, and let's buy the center, Gary, and do it. So it was a lot of questions asked. Why did you do this asset? Well, why is this, this asset? Why do you have a loan back on this one, on this Louisiana one, personal? So, when it comes to I want to say a family business, there's a lot of moving parts that are not typical. If it was, let's say, yourself and me being partners, where it was much more of a defined relationship, this wasn't that. There was a lot of things that went on. And I will say this, 90, 100 days, June or so or whatever, they realized that there wasn't $1 that was taken from the company. There wasn't one development fee that that was not owed, even though I subsequently, to settle this thing, I waived all those fees, and I prevailed on that. So for me, yeah, it would have been great to get all that money back, but I wanted to clear my name because it was a huge allegation against me personal, and it was tough times, man. I wish I never gotten through it. I wish I would have just rode off on my little horse in 2011 and never had to return.
I'm good.
Thank you, and thank you for your testimony. I know that that was a difficult time for you. I'm sorry for your father's loss. We're gonna take a 10-minute break before we continue with cross-examination, and then my co-panelists and I will probably have some questions as well. So if everyone could come back at 10:50, we're going to close the record now, but please be mindful that the live stream is continuing. So if you're talking, please turn off your microphone. think we're ready to resume. We're going to reopen the record in the appeal of Safady. Franchise Tax Board, you requested 30 minutes for cross-examination.
We do not have any questions at this time. Thank you.
Okay, thank you. Well then, at this time, I'm going to ask my co-panelists if they have any questions. Judge Lambert, do you have any questions?
I have no questions at this time.
Judge Johnson, do you have any questions?
If Mr. Safady would be around for the rest of the hearing, I might save questions for later if that works.
Pardon?
You'll be around for the rest of the hearing, correct?
Yeah, I'm here, yes.
Okay, I'll
Yes,
save
sir.
questions for later then. Thank you.
Thank you.
Well, I do have a few questions. So I think probably for Mr. Safady and Mr. Mohan. First, I wanted to clarify, so my understanding is that the Nichols Canyon Road property was rented periodically, and in the briefing, the earliest indication is May 29th, which is after, at this point, the issue that FTB is asserting residency changed. What was the property just vacant between January 1st and that May 29th date?
It was available for photo shoots. It was available for rent, and it was listed for sale. So after 2010, I can't remember more than 1 or 2 times ever going back there. For me, looking at that was just, while it may be an asset to some, it was a liability for others. And I was trying to sell that. I bought it with the intent to fix it up and sell it. And it took me almost 5 to 7 years to sell it. And I finally sold it, I think, in 2014. But I leased it. I did, there was a GQ photo shoot there. There was a Eric Roberts movie filmed there. There were several tenants on and off there. So it was always available for generating income only.
Thank you. And then with respect to the Wanda Park Drive property, I know that that was converted into a workspace. When was that converted?
It was converted at the end of 2010, I believe it is.
And that was then used by O&S, is that correct?
No, it was owned by 9712 Opash Road, LLC, and O&S signed a lease in 2010, probably early 2010, I want to say. And then during 2010, we had to convert it because when we didn't buy the property where all the office was, we needed a place to go, and I had that space available, and we gutted it all and put in, like I said, it was about 20 workstations. We had Cat5 cable going to every single workstation because back then, it wasn't so much wireless. And then we had 2 T1 lines from AT&T installed to operate all the servers and stuff.
And the LLC that owned the property, was that your LLC?
That was my LLC, sir, yes.
Okay. And then you had mentioned in your testimony that your cousin did not want to pay rent for the Wanda property while you were living there, and so you moved out. Did that happen in
Well,
2010?
That was probably I don't remember the specific date, end of 10, beginning of 11, right around there. Okay. And so that's when I moved I stayed with my girlfriends.
Okay. And then I want to cover, I have a question about the briefing, so this is probably more appropriate for Mr. Mohan. So the December 14th, 22 reply brief, it states that appellant agrees to roughly 106 days in California, and then asserts that he spent 111 days in Las Vegas. There's a credit card schedule which is now identified as Appellant Exhibit 8. And that covers, that schedule shows 21 days worth of charges in Las Vegas. Is there, first, two questions. First, is there the source documentation that was provided with that schedule that corroborates those dates? Is that correct? Because I know you provided some city.
Yeah, yes, I'm sorry.
Thank you. And then the other question I have is there evidence, similar evidence supporting the remaining days in the that are asserted here? Because obviously it's
Evidence for California days is your question?
no, for Las Vegas, because you assert in that brief 111 days in Las Vegas, and then that schedule only shows charges for 21 days. So I'm wondering how we make up the difference. If you look at Exhibit 8, you can see.
Yeah, I'm looking at it. I get the 20 days. This calendar, as I tried to explain in the opening, encompassed all of the detail that's attached in Exhibit A. And as you'll look, the credit cards, I'm on page 3, I think. The bottom, Gary Safady, Jose Mata, which is Carlos, and then Shannon Melick was his assistant. On the original FTB schedule that was prepared by the auditor, they included all of these charges as if they were being personally incurred by Mr. Safady. When we went through, I don't think I can distinguish, I don't think he can distinguish, or the Franchise Tax Board, all of the charges that would have been California. The only thing we know is that we found 20 that are definitely his because no one else would have been in Nevada. But based on that, we went back and tried to figure out from airline records and other things in his life, trying to narrow down the actual number of days, which would have increased the Nevada days. And we get back to that same problem with the calendar in that if he is there on a Tuesday and leaves and gets there at 8 o'clock at night in Las Vegas, is that a California or a Nevada? So at that point, we kind of threw our hands up because his calendar, really, if you look at the original calendar that was provided by the accountant in the audit, the original calendar, most of those dates are phone meetings or something else that really doesn't tie to California. So I don't know that a specific date of being in California or a specific date of being in Nevada is actually ascertainable 15 years later.
Okay.
So what we've done is just taken what was started with and kind of narrowed it down where we can exclude, days that we knew we weren't in California.
Gotcha. So those dates, that schedule then is intended to contradict the calendar dates showing that
Correct.
he was in. Okay. And then, so then regarding the calendar, I'm looking at now Franchise Tax Board's Exhibit H. That was provided by Mr. Safady's accountant then?
That's my understanding.
Okay.
And I think let me look at it. The original calendar of days was provided originally by FTB because the calendar that the accountant provided was more of a printout, a screenshot of days from whatever program they were using at that time. I don't know what that program was, but which would just have date appointments and you can't read the whole descriptive part. So I think at that point in time, the auditor was a little bit frustrated and went back to try to figure out the charges and went through bank statements and credit cards to try to ascertain where he was.
Okay, I understand, but I'm looking at the calendar right now, and if you could look at, for example, February 2012, I understand the contention that you couldn't read the appointments, and so that was where the auditor sort of asserted deviations based on credit card charges. But here it shows, you know, just a long bar for Beverly Hills from the 2nd until the 12th, and then again from the 14th to the 29th. So are we saying then that that's inaccurate, or are we going, or was Mr. Safady, were you driving back and forth for all of those days, or?
At the end of the day, I don't know that it matters, because if he was, just for sake of argument, if he was there from January 1st till August 14th, I still think it fits under the temporary and transitory. He was there for a purpose, for a function, for a job. That's why we kind of got off of the calendar, other than it was more important to me to show that he actually had Nevada as his residence. That's where he went back each time he was gone. So whether it was 50 days or 110 days, I don't think it makes much of a difference in the analysis. The point is, he clearly did not have a residence or some place to live that he went back to in California. And that's probably since the split up with his girlfriend, and he was no longer living with her. He didn't really, there's no California residence. He didn't own one, he didn't rent one. He couldn't live in one. And obviously living in his parents' house is not his home. So I get your question. I don't know that I have a good answer for it, because we can't be that specific. Do I object to the number of days? No. But I don't think the number of days were actually that much.
Okay,
We
and
even
then,
tried to go back to the billings from Gerber, from Cabot, and from Venable to try to figure out, you know, how many meetings he would have had. But most of their time, if not all of their time, is just what they had actually physically done.
okay, thank you. I don't have any additional questions. Actually, I do. With regard to the credit card schedule, those statements all went to an address in California. I don't recognize. Was that a business address? What address was that?
That was the new accountant that I brought on. So in October, I think, of 2011, the HCVT was the accountant for myself, my partner Paul, and it's Gerber's, and the company. And when they terminated me as their client and they sided with my partner Paul, I had to bring on an accountant, and part of his services was bookkeeping and stuff like that. So he was doing check writing, everything. They offered that service, and so all my statements went to them. Everywhere went to, that's the Gerber and Associates, their office address.
Okay, thank you. That clears that up. I have no additional questions. I think we are ready to move forward with Franchise Tax Board's presentation. Franchise Tax Board, you requested 30 minutes, and you may begin when ready.
Good morning. My name is Desiree Macedo. Joining me today is Ron Hostel. Together, we represent Respondent, the Franchise Tax Board, in this matter. Respondent's presentation will begin with a discussion of residency in general, continue with a discussion of domicile and the meaning of temporary or transitory, and conclude with a discussion of appellant's connections with both California
Ms.
and...
Macedo, I'm sorry to talk over you, but can you slow down? Like half speed?
Yes, California and Nevada. This matter is essentially a timing issue. It is undisputed that appellant was a California resident prior to November 2nd, 2011. On May 18th, 2012, ONS Holdings, LLC, an entity owned in substantial part by appellant, sold a shopping center located in Huntsville, Alabama. What is disputed is appellant's residency status from January 1st, 2012 through May 18th, 2012, the date of the sale. It is appellant's position that he became a Nevada domiciliary and a California non-resident on November 2nd, 2011, and remained so for about 10 months. Conversely, it is respondent's position that appellant did not become a California non-resident until at least August 2012, when he relocated to Florida. The purpose behind California's taxation of residents is to ensure that individuals who are physically present in the state and enjoying benefits and protections of its laws and government contribute to its support, regardless of the source of the taxpayer's income. As pointed out in all presidential OTA residency decisions, including the appeal of L. Mazer and M. Mazer, the appeal of J. Bracamonte and J. Bracamonte, the appeal of D. Beckwith, and the appeal of B. Hausman and B. Pena, the question of whether taxpayers continued to avail themselves to the benefits and protections of California underlies all residency decisions. Determining residency starts with the statute. A California resident includes 1. Individuals inside California for other than a temporary or transitory purpose, regardless of the taxpayer's domicile. This prong will be referred to as A1 throughout the remainder of respondent's presentation. And 2, individuals domiciled in California who are outside for a temporary or transitory purpose. This prong will be referred to as A2 throughout the remainder of respondent's presentation. A California non-resident is defined as every individual other than a resident, and a part-year resident is a resident who, during the same taxable year, is a resident of the state during a portion of the taxable year, and a non-resident of the state during a portion of the taxable year. Pursuant to Revenue and Taxation Code Section 17014C, an individual who is a resident of the state continues to be a resident, even though temporarily absent from the state. Therefore, the determination of appellant's residency is essentially a two-part test. It starts with determining appellant's domicile and concludes with weighing factors to determine whether appellant was either inside of California for other than a temporary or transitory purpose, or whether appellant was outside of California for a temporary or transitory purpose. Analyzing a taxpayer's connections within and without California is ultimately designed to determine whether the benefits and protections are consistent with California residency. Moreover, it is well-settled law that a person can be a resident of more than one state or taxing jurisdiction at the same time. Presidential OTA cases, including the appeal of Mazer and the appeal of Bracamonte, essentially put a taxpayer's connections into 3 silos. 1, connections acquired, 2, connections severed, and 3, connections maintained. In most situations, when a taxpayer claims to have changed his residency from California to another state, the question on appeal is whether taxpayer has met his burden to show that he not only acquired substantial connections in his new state of a claimed residency, but that he severed his longstanding connections with California. If it is determined that appellant was domiciled outside of California, he could be deemed a resident only under A1. If it is determined that appellant was domiciled inside of California, he could be deemed a California resident under A1, A2, and/or C. Typically, individuals who are domiciled inside of California do not dispute they are residents under A1, because that means they are California domiciliaries who are inside of the state for other than a temporary or transitory purpose. However, excluding California domiciliaries from the definition of A1 would mean that California does not have a basis to tax California domiciliaries who do not leave the state during the taxable year. And that would be inconsistent with public policy reasons for taxing individuals. Therefore, in the present case, it is clear appellant was a California resident under A1, A2, and C. I will now discuss the domicile analysis. As stated in the appeal of Beckwith, in order to change his domicile, appellant must have an actual physical presence in the known locality and the intention to remain there. As stated in the appeal of Mazer, appellant's own actions must support a change of domicile. Unsubstantiated statements will not suffice. Further, if there is doubt, then appellant's original domicile remains. During the period at issue, appellant continued to have actual physical presence inside of California. Pursuant to appellant's own contemporaneous physical presence calendar, which is in the record as Exhibit H, during the period of January 1st, 2012 to May 18th, 2012, appellant spent approximately 69 days or 50% of his time in California and only 16 days or 12% of his time in Nevada. Contrary to appellant's assertions, during the period at issue, appellant had access to multiple California-based abodes, including the properties he owned either directly or indirectly through his entities, and his parents' familial abode where he and his children regularly stayed. Importantly, while appellant claims that his ex-wife received their California-based abode as part of their settlement agreement, appellant undisputably remained a California domiciliary for 3 years after the dissolution of their marriage, and agrees that prior to the period at issue, he resided in one of the California-based abodes that was also available for his use during the period at issue. As such, appellant had actual physical presence in California. Furthermore, during the period at issue, appellant's own actions demonstrate appellant intended to remain domiciled in California. Importantly, appellant's familial abode remained in California. Appellant's 3 minor children, whom he financially supported, 2 of which he claimed as dependents on his tax returns, continued to reside inside of California. Additionally, appellant claims that he acted as a caregiver for his ailing parents who resided inside of California. Importantly, the fact that appellant filed a California resident income tax return for the 2011 taxable year and reported he was a domiciliary and resident of Florida on the Schedule CA for the 2012 taxable year demonstrates that appellant did not have the intention to change his domicile to Nevada during the 2012 taxable year. In addition, during the period at issue, appellant continued to own and remain actively involved in his California-based businesses and properties. He continued to register vehicles in California. A majority of his professional services took place in California, and most, if not all, of appellant's legal and professional correspondence was directed to a California address. Therefore, during the period at issue, appellant's own actions demonstrate an intention to remain domiciled inside of California. It appears that appellant argues that but for all of his California connections, he would have relocated to Nevada. However, recent OTA case law, including the non-presidential decisions and the appeal of Q-Tran in R. Medina, as well as the appeal of R. Peters, demonstrates that appellant's argument is not persuasive. As such, the 2 prongs needed to demonstrate a change of domicile, action, and intention are not met in the present case. Therefore, appellant remained a California domiciliary through at least May 18th, 2012. As stated in the appeal of Mazur, the analysis then shifts to whether appellant was either inside of California for other than a temporary or transitory purpose, or outside of California for a temporary or transitory purpose. The key question under A1 or A2 is whether appellant's purpose in either entering or leaving California is temporary or transitory in nature. The residency regulation provides guidance in this regard. The connections that a taxpayer maintains with this state when compared with other states are important indications of whether a person's entrance to or absence from California is temporary or transitory in nature. Such connections are an objective indication of whether the benefits and protections that the taxpayer has received from the state of California are consistent with that of other non-transitory inhabitants. In the appeal of Stephen Bragg, the Board of Equalization provided a list of non-exclusive factors that were helpful in evaluating a taxpayer's connections in prior appeals. In the OTA decision in the appeal of Mazur, the factors discussed in Bragg were separated into 3 categories. 1, physical presence and property. 2, personal and professional associations. And 3, registration and filings. As stated in the appeal of Bracamonte, the physical presence factor is given greater significance than mental intent and formalities that tie one to a particular state. Further, as stated in the appeal of Tyrus Cobb, a mere formalism, such a change in registration or a statement that appellant intended to be a resident of another state, does not ordinarily settle the issue. Appellant's relevant connections to both California and Nevada will now be discussed in the appropriate Mazur groupings. I will first discuss the physical presence and property category. The OTA has given this category the most amount of weight in determining a taxpayer's connections to California. In this category, I'll be discussing the physical presence and property factors, starting with the physical presence factor. Based on appellant's own physical presence calendar, which was provided during the audit examination, during the period of January 1st, 2012 through May 18th, 2012, appellant spent approximately 69 days or 50% of his time in California and 16 days or 12% of his time in Nevada. Significantly, appellant's time in California averaged 10 days at a time. The longest continuous stay was a period of 28 days during the month of February. Conversely, appellant was only physically present in Nevada for 16 days during the entire period at issue. The longest continuous stay was the 7-day period from January 10th, 2012 to January 16th, 2012. After which time appellant was inside of Nevada for 1 to 3 days at a time. Therefore, it appears that the purpose of appellant's sporadic visits to Nevada was for vacation with friends and for business purposes to oversee the Mall Ring Circle project, which was experiencing financial hardship, which according to appellant, he abandoned by the middle of 2012. As such, pursuant to A2, appellant's presence inside of California prior to the sale was clearly for a temporary or transitory purpose. Additionally, if this case was to be reviewed under A1, appellant's presence inside of California was for other than a temporary or transitory purpose. Appellant's reasons for being inside of California prior to the sale was to comply with family court visitation order, to financially and emotionally assist his dependent children, his ailing parents, and his other financially dependent relatives, to finalize his ongoing business lawsuits and to conduct ongoing business, including meetings for Safady Entertainment, business meetings with new investors, site visits for his various California-based properties, meetings with architects for new projects, and meetings with potential buyers on his California-based properties. Appellant argues on appeal that his significant physical presence inside California during the period at issue was temporary or transitory in nature, as he was merely inside of California to finalize the terms of the reorganization agreement. However, it appears that appellant was not actually required to be inside of California as often as he suggests in order to assist with these negotiations. In fact, when Mr. Gerber was asked if he agreed with the statement that he made in his declaration from the third quarter of 2011 to December 31st, 2012, every day that appellant was physically present inside of California, someone from Gerber and Company met with appellant in person, Mr. Gerber responded that that statement was inaccurate. Moreover, when Mr. Cabot was asked if he had any specific memory of meeting with appellant on a date other than May 8th, 2012 or May 10th, 2012, Mr. Cabot replied no. Further, Mr. Cabot agreed that more often than not, when he communicated with appellant, it was over the phone, email, and text. As such, it appears that appellant's presence inside of California was to maintain his long-standing California connections rather than to complete a particular transaction. Clearly, appellant had a significant physical presence inside of California from January 1st, 2012 to May 18th, 2012, and an insignificant physical presence inside of Nevada. Therefore, regardless of which prong is applied, the physical presence factor, which is given significant weight, clearly favors California residency. I will now discuss the property factor, which also favors California residency. Appellant's own physical presence calendar clearly demonstrates that during the period at issue, he primarily resided inside of California. Appellant claims to have lived in a 3-bedroom rental property at the Vera Towers in Las Vegas, Nevada from December of 2011 until his move to Florida in August of 2012. However, during the period at issue, appellant owned, either directly or indirectly, either directly or indirectly through his various entities, multiple California-based abodes, where on page 19 of appellant's opening brief, appellant claims he resided for approximately 30 days during the 2012 taxable year. As stated in appellant's opening brief, pages 10, 11, and 19, appellant had access to his parents' abode where he primarily stayed during the period at issue. Moreover, as appellant stated on page 11 of appellant's opening brief, appellant concedes that during the period at issue, when appellant had custody of his children, it was at one of the California abodes, primarily his parents' house. When comparing appellant's California and Nevada-based abodes, it's abundantly clear that appellant had a greater connection to the California-based abodes. Therefore, the property factor, which is given significant weight, also clearly favors California residency. When viewed as a whole, the physical presence and property factors favor California residency. I will now move to the second category, the personal and professional associations category. The OTA has given this category the second most amount of weight in determining a taxpayer's connections to California. In this category, I will be discussing the familial abode factor, professional services factor, business associations factor, membership factor, and bank account factor. The first factor I will discuss is the familial abode factor, which favors California residency. During the period at issue, appellant's familial abode was located inside of California. As stated on pages 5 and 6 of appellant's opening brief, due to appellant's financial success, he is considered the patriarch of his family and was the first point of contact when his family members needed help in an emergency. Appellant's parents, his 3 brothers, and their children leaned on him regularly, not only for financial assistance, but also for emotional support. In fact, appellants assert he was one of the primary caregivers of his father when his father was ill, often staying at his parents' house. Additionally, appellant asserts that he paid for the purchase and remodel of his parents' home. Appellant lent one of his brothers money to help him pay for his mortgage and his nephew's tuition. Then, when his other brother became unemployed, appellant gave him a job at ONS Holdings, where he worked until its dissolution. Appellant also gave his mother and another brother a monthly stipend, plus financial assistance as needed. In addition, appellant claimed his 7-year-old son and 17-year-old daughter as dependents. It is uncontested that appellant's children remained in California during the period at issue, and that appellant and Ms. Safady agreed it would be in the best interest of their children to continue their education as the French immersion school was located inside of California. This makes sense considering appellant was rarely inside of Nevada. Given that appellant's legal dependents resided in California, appellants receive benefits and protections from the state of California. Therefore, the familial abode factor, which is also given significant weight, favors California residency. Additionally, based on the pending litigation in California, appellant's legal counsel, accountants, and financial advisors were all based out of California. Appellant also continued to retain his California-based psychologist for therapy sessions. As such, appellant continued to receive benefits and protections from the state of California in regards to his professional services. Therefore, this factor should also be, which should be given little weight, also favors California residency. During the period at issue, appellant possessed at least a 50% interest in approximately 35 entities, many of which were doing business inside of California. Therefore, the business associations factor also should be given, which should also be given little weight, favors California residency. Additionally, as stated in respondent's briefing, the membership factor should be considered neutral in determining California residency, as appellant was not physically present in Nevada to attend church on a frequent basis. And the bank account factor slightly favors California non-residency, since appellant did not use the Nevada-based Wells Fargo checking account, and all those statements were in fact mailed to a California CPA firm. Therefore, when reviewed as a whole, the personal and professional associations category favors California residency. The last category I will discuss is the registrations and filing category. The OTA has given this the least amount of weight in determining a taxpayer's connections to California. In this category, I'll be discussing the Secretary of State filings factor, vehicle registration factor, voter registration factor, and driver's license factor. The Secretary of State filings factor favored California residency, as appellant continued to remain the agent for service of process for 5 of his businesses that were registered in California. Additionally, the vehicle registration factor also favors California residency, as appellant registered 2 vehicles with the state of California and 0 with the state of Nevada. The voter registration factor should be considered neutral in determining California residency, as appellant did not exercise his right to vote in Nevada during the 2012 taxable year. And the driver's license factor is neutral in determining California non-residency, since appellant stated on page 22 of appellant's opening brief that he claimed he rarely drove in Nevada since he stayed on the Las Vegas Strip. Therefore, the state where appellant received benefits and protections in regards to his driver's license was actually the state of California. When reviewed as a whole, the registration and filings category slightly favors California residency. Therefore, all 3 of the major groupings, physical presence and property, personal and professional associations, and registration and filings, favor California residency. In summary, during the period at issue, appellant continued to remain domiciled inside of California and was absent, if at all, for a temporary or transitory purpose. Additionally, appellant was physically present inside of the state for other than a temporary or transitory purpose. As such, during the period at issue, appellant received benefits and protections consistent with California residency from the state of California, regardless of any connection he may have made to Nevada. Therefore, respondent's determination should be upheld. Thank you. That concludes my presentation. I'd be happy to answer any questions the panel has at this time.
Thank you. Judge Lambert, do you have any questions?
This is Judge Lambert. Yeah. I just, after hearing FTB, I just had another question for appellant, Mr. Safady. I was wondering if you could clarify something, or maybe you explained it already, but there was a move to Vegas and then a move to Florida, and just there was a couple differences, like you rented in Vegas and then purchased in Florida, and you were staying kind of closer to your family after the move to Vegas, but Florida, it seemed like you were further from your family and father, and you spent less days in California. So, you know, assuming you always meant to sever your connections to California upon leaving for Vegas, can you clarify the differences, why there was differences in terms of being away from your family, days in California, and the rental versus purchase? And I know there was that ending of the legal dispute in August 2012, and maybe that was a part of it, but maybe you could clarify those differences.
So just help me understand the questions. You're really, why did I move to Florida? Was that really it?
Why did you purchase in Florida but not purchase in Vegas?
Okay,
And then
sure.
you were talking about being close to your family, but in Florida you
Yeah.
were further away.
Yeah, yes, sir. So in 2011, when I rented the place, my liquidity was rock bottom. And in July of 2012, I think it was, when I went on a trip overseas, I saw some business opportunities. When I signed the August 2012 agreement, I got released to me, I think it was $2 million. With that, I had liquidity to buy something, and I bought the property in Florida, you know. And so I ended up leaving in I think it was October 2011 to Florida. My ties with my whole family, I really didn't, other than going to see my dad when I felt it was necessary or to stay there overnight, I didn't still see my kids that much when I was in LA. It was just, they were either at school, and I had an agreement with my ex-wife that I'm going through a lot, just, she's a great mom, and I have 100% trust, or my assistant Carlos would take them around, take them to lunch, pick them up from school, but would always return back to their home. And then after my trip in California, I'd return home back to Las Vegas. So the short answer is I had no liquidity to buy a place in Vegas.
Thank you. And also, just to clarify, for the legal dispute in California, that was something that required you to be in person, and it couldn't be something just done in long distance?
No, absolutely. There was a conference room, you know, that there was 35 entities, say maybe 100 to 200 boxes in there that had to go through. So even the attorneys, after all that legal work and everything that was done, they still got it wrong. I was supposed to get X, I got X minus 50%. And I got all the gains, I got zero cash, and I got all the tax liabilities when that sold, especially Huntsville. I got zero cash from that deal. And so even after 2012, you know, it was like another thing just hit me. Like I was thinking I was done. And moving to Florida in October is when I started to do business overseas, and it's a lot closer from Florida to get there than from, you know, I had to search and try to find money, where to make money. And so that was, I saw Vegas, the opportunities were just, Vegas was hit extremely hard. And I didn't see any opportunities there in business, which I hoped for. I saw it overseas, and that's when in 2013, at the end of 12 or 13, I opened up an office in Liberia, Africa. So I ended up packing up and moving to Florida after that, after, you know, my home in Vegas.
Okay, thank you. Appreciate it. That's all I have.
You're welcome.
Judge Johnson, do you have any questions?
Not at this time, thank you.
I had one question for Franchise Tax Board. So with respect to the revised date for changing residency, does that affect the calculation of the tax?
It does not. The primary issue on appeal is the sale of the Huntsville, Alabama purchase and sale. Therefore, that we reduced the issue to primarily limit to the sale date. However, we don't disagree that we don't change our position of when appellant became a California non-resident, just that the primary issue on appeal is the date of the sale.
Okay, thank you. Before we close, I'd like to give appellant the opportunity to make their closing statements, but I also wanted to offer a 5-minute break if you'd like to discuss before you make your closing statement. Okay, then we will go off the record and we will reconvene at 11:40. I believe we're all ready to go. We're reopening the record in the appeal of Safady. Mr. Mohan, you asked for 10 minutes to make your closing statement, and you may begin when ready.
Thank you. I'll keep this short. As I said in my opening, there are a ton of cases out there trying to ascertain where somebody really lives. Closer?
Better, thank you.
Where somebody really lives. I think it's very clear, both from the record and from Mr. Safady's testimony, he didn't have a place to, he had a place to stay. He didn't have a place to live in Los Angeles. He testified that if it wasn't for this litigation, he would have been back a couple of times, probably to see his father when he first fell and to help him along, and then when he had a later health problem. All the other litigation that we're talking about, he could have handled by phone, or at least minimal visits, whether it's Huntsville, Alabama, or Texas, or Joliet, Illinois. That stuff didn't need his presence to go through and sort out these many years of relationship with his cousin. And it got even more personal and required even more of his time when he made the allegations that he misappropriated funds. There was nobody else there to do it. There wasn't somebody in the office during the first 20 years that does that. He did it. He wrote the checks. He stamped the invoice to it. He put it in the file. He had to find it. It would have been nice if they could have moved all these boxes from the storage facility in Santa Monica or wherever the other one was to Vegas so he can go through them, because he could just answer the questions. But because the attorneys had him in Los Angeles, either we're moving 15 sets of attorneys to Las Vegas to go through these boxes and pay him for them, or Mr. Safady makes the move. I've gone through most of the factors to refute the board's statement. One thing I wanted to point out, this concept of getting protection from the state, or the benefit of protection of the state, even as a non-resident, he's still paying tax in California. He's got 4 or 5 properties that generate income, and he paid tax when they sell, so it isn't like he's skirting the benefits and burdens of being a citizen. He is paying the tax as a non-resident. That doesn't change. The only reason this case is here is because it's a money grab for the big sale in May. And it's just, and I said it in my opening, it's curious to me that January of 2012, wife and kids are in Los Angeles. May, they're in Los Angeles. August, they're in Los Angeles. December, they're in Los Angeles. That didn't change. So I don't understand why it's a factor. And the fact that the board is, at one point in time, I think after on the original MPA, at that point in time, they conceded after August, he's no longer a resident because he's in Florida. And again, I don't think that's true. He bought an investment property in Florida, which I think Judge Lambert was getting at. His original intent was to be in Los Angeles or in Las Vegas so that he was close to his kids in case that was it. But he wasn't in a position, whether it's financially or mentally, to have the kids there every other week, and they agreed, and his ex-wife had agreed that that didn't happen. They may have visited, I think he said, a couple times in Las Vegas. But he had it set up as a home, so if his kids did come, he would have it. Otherwise, he could have got a little one-bedroom studio for probably a third of the price, especially back then when Las Vegas was really hurting. The other notion of all of his stuff being in California, that also is not true. The office moved to Huntsville, Alabama. There was still people in Los Angeles, and there was project in California, but his most valuable projects were in Huntsville, or even the development project in Joliet, Illinois. That could have been a $700 million deal if the city had come through like they had promised originally. But when that fell apart, that project wasn't as worthwhile. But that was where he wanted to spend his time and his effort to make more money. He didn't need to be in Illinois. He didn't need to be in Huntsville. And if he did, it'd be for a day or two. This particular litigation required him to be there when he didn't want to. He was in a dark spot, got divorced, Probably 30% of his net worth went down when the economy crashed, and whatever was left was being fought for by his partner, who every time he turned around was making some kind of allegation against him that he had to go defend. At the very end, towards June, July, the only thing he really helped with, which was critical, was the fact that all of these entities, I haven't gone through all the transaction, but it sounds to me like they were rolling up all the entities in an effort to divide them in two. Instead of having 50% of each project, they would just divide them and trying to do it tax-free. But no one knew the entities, not even his partner. You know, he was the money guy. He would know where a project was, might have driven by it, but hasn't been in the office, never wrote a check. He was the manager. So for those reasons, I think it's fairly clear that there is no other home during 2012 than Las Vegas. He didn't have any of those, the two properties, Wanda Park or Nichols Canyon, those weren't a home. If he stayed there a night, it's still not a home. It's no different than a hotel express room. He's not expecting to stay there. He didn't hang pictures. He didn't buy a week's worth of food. Same thing with his folks. You know, whether he stayed at his folks' house or his brother's house, you know, he could have pitched a tent in the middle of a park in Los Angeles. His intention was not to stay in Los Angeles. He wanted out. And he moved out. If he's trying to do it as a facade, you know, he could have rented an apartment, never showed up, never bought furniture. I mean, he didn't like, during that period of time, he had a bunch of money to spend. He was doing it to set up his own home, period. Thank you very much for your time.
Thank you. And I just want to check in with my co-panelists. Judge Lambert, do you have any final questions?
I have no final questions.
Thank you. Judge Johnson, do you have any additional questions?
No, thank you for your testimony and your time today.
Yes. I also want to say thank you again for coming, and I hope you have safe travels home. We are ready to conclude this hearing. This case is submitted on Tuesday, April 21st, 2026. The record is now closed. I want to thank everyone for coming in today. The judges will meet and decide your case later on, and we will send a written opinion of our decision within 100 days. Today's hearing in the appeal of Safady is now adjourned, and the hearings will resume at 1 o'clock. Thank you.